Your Honors, my friend was served with an expert report in compliance with the rules authored by Dr. Butkowski, who's a practitioner pursuant to Section 52 of the Evidence Act, and he will be our next witness. Dr. Butkowski, I'd like to begin today by briefly reviewing your qualifications as set out in your curriculum vitae, and Your Honors, you can find that at tab 4A of the trial record, which is followed by his report at 4B.
I'm prepared to admit Dr. Butkowski's qualifications.
Well,
Dr. Butkowski is well known to the court.
I don't intend to belabor his qualifications, Your Honor, but it is important that the court have the benefit of knowing what particular expertise he has that's relevant to the issues and the actions. It won't take me more than 60 seconds. Dr. Butkowski, I take it that you graduated and achieved your PhD in clinical psychology from the University of Waterloo in 1982?
That's correct.
And so how long have you been a registered psychologist in Ontario?
I have been registered as a psychologist in the province of Ontario since 1982.
And would you describe the nature of your practice briefly?
I have a full-time clinical practice in which I conduct custody and access assessments, predominantly for the Superior Court of Justice of Ontario. I'm a family mediator, and I have a very broad-based practice in psychotherapy in which I treat adults, children, couples, and families.
And what is your specific experience with mood disorders?
During the course of my graduate training toward my master's and doctorate, I received training in the assessment and treatment of broad-based spectrum of mood disorders. Between my second and third year of graduate school, I spent 4 months in a full-time clinical internship in which I served on the adult psychiatry outpatient team at Kitchener-Waterloo Hospital, where certainly the preponderance of clients that I dealt with suffered from some form of mood disorder.
Now, Dr. Butkowski, do your professional credentials make you competent to diagnose mental health disorders?
Yes, pursuant to the Regulated Health Professions Act, a psychologist is qualified to engage in the controlled active diagnosis.
And have you been qualified by as an expert by this honorable court before?
Yes, I have.
I'd like to tender Dr. Butkowski's curriculum vitae as the next exhibit in case my friend wishes to ask any further questions on it. Now, I understand that my friend sent you a letter and asked you to bring your clinical notes and records with you today?
Yes, Mr. Epstein sent me such a letter yesterday evening.
And are you prepared to produce them today?
After careful consideration and reflection on my obligations to my client and my obligations to the court, I am. I was concerned when asked to bring my notes and record that the disclosure of the information to my client might cause her some significant psychological harm, and equally concerned that the disclosure of such information might compromise my ability to continue to provide her with the psychotherapy on which she has relied since being referred to me, in that it could impact on the trust in the relationship. In attempting to balance my obligations to my client and to provide some reasonable basis for the evidence that I was asked to give here today, I spent the last several weeks going over all my notes and records with my client and reviewing them with her in order to understand that she fully understood what information I might provide and that she would not be caused any irreparable emotional harm, nor would this therapeutic relationship be unduly affected.
Now, I'd like to ask you about your record-keeping practices. Do you make your notes contemporaneously with the session with your client or patient?
No, that is not my practice. I believe that to make process notes interferes in the therapeutic relationship, and accordingly, I make my notes immediately after the session.
And are your record-taking procedures in compliance with the requirements of your governing body?
Yes, they are.
Now, I'd like to focus for a moment on the methodology that you used in reaching the opinions and conclusions that are contained in your report. Generally, how do you go about making a diagnosis, Dr. Bukowski?
The diagnosis is generally based on numerous sources of information which seek convergent validity. Primarily, I would rely on the observations that would be obtained in diagnostic interviews, information that is provided by the client via self-report. In this instance, I also had occasion to discuss Ms. Brown's functioning with the referring physician, Dr. Franks, and as well I engaged her in a battery of psychological tests in order to confirm the diagnosis. Subsequently consulted the Diagnostic and Statistical Manual, the fourth version. The Diagnostic and Statistical Manual being the preeminent authoritative source for diagnostic classification used not only in Canada but internationally, and that is the one that I use as opposed to a second manual which is available and is referred to as ICD-9.
Now, I take it from your reference to the DSM-4 in your report and to the evidence that you just gave that you accept it as an appropriate and authoritative diagnostic text?
Yes, I do.
On that basis, I would like to tender as an exhibit today the excerpts from the DSM-4 that relate to the mood disorders that are the core issue in terms of Ms. Brown's mental health and her capacity or lack thereof to work. Next, I would, unless you object, my friend has, well, perhaps you could state your reason for the objection.
Yes, I object to tendering as an exhibit excerpts from textbooks, manuals, or anything of the sort. That's not relevant evidence before the court. It's not proper evidence before the court. And it certainly can't go in by Dr. Bukowski since he is not the author of such articles.
With the greatest of respect, that's a misstatement of the law, and so long as an expert witness adopts an authoritative text as being authoritative, it can be submitted through that witness, notwithstanding that they are not the author. This text and forms the basis of the examination and will assist the court greatly in understanding how Dr. Bukowski arrived at the diagnosis, which is the subject of the challenge today.
Right, I'm going to allow it. Council can argue in their closing as to whether any weight should be placed on it.
Thank you, Your Honor. Now, with that text in hand, I'm going to focus a little bit now on the diagnosis and treatment of Susan Brown. And I'd like you to elaborate on that. And first, I'd like you to tell us how long Ms. Brown's been in your care.
Ms. Brown was referred to me in mid-May of 2001, and accordingly, she has been a client for approximately 2.5 years.
And how did she present to you initially?
She presented with clearly depressed mood. She was very emotional, very anxious in the interviews, very fidgety. She cried easily and often and was not able to sustain any effective emotional control. She appeared to move and speak very slowly. She complained of an inability to concentrate and sustain attention to tasks. She complained of weight loss and loss of appetite, sleep disturbance, which is characteristic of depression, including difficulty falling asleep and early awakening, and complained of fatigue and being unable to get out of bed, as well as a number of other familiar symptoms.
Now, turning now to the excerpt that has been provided to the court and using it as an aid if necessary, would you describe the features of a major mood disorder?
A major mood disorder requires initially that the symptoms have persisted for a period of no less than 2 weeks. It requires that there be the presence either of a depressed mood or a loss of interest or pleasure in previously enjoyed activities. And it requires, in addition, a minimum of 5 other symptoms, which would include difficulty with concentration, disturbance of appetite and sleep, emotional lability, psychomotor agitation or retardation, which means being very agitated physically or moving very slowly, diminished ability to process information, disturbances in thinking, and may include recurrent self-destructive and suicidal ideation.
May I direct you to page 356, which sets out the criteria for a major depressive mood. And you indicated in your evidence earlier that there must be the presence of several of these in order to reach that diagnosis. And
That's correct.
You just gave us a list of some of them. Would you tell the court if any of these criteria were present or are present in the case of Ms. Brown?
It was certainly my observation in the course of my initial diagnostic interviews of Susan Brown that she both displayed and reported depressed mood characterized by evident sadness and frequent tearfulness. It was also clear that she had lost interest in a variety of previously enjoyed activities and that she was deriving little or no pleasure from any of the day-to-day tasks that she was engaged in. She reported difficulty with sleeping, as I mentioned earlier, characterized by difficulty both falling asleep and awakening early in the morning. She reported feeling lethargic and fatigued, unable to get out of bed, unable to engage in day-to-day tasks. She also reported disturbance of appetite. She had apparently lost approximately 10 or 12 pounds at the time that I saw her some 2 weeks after separation, was having difficulty eating. And I certainly noticed on interview some disturbance in her thought processing characterized by an inability to sustain a conversation, likely a function of thought blocking, and as well a tendency toward tangential and at times circumstantial thought. And at the time I also wondered about the presence of possible delusional content based on some of the information she was presenting, but was unable to corroborate that because my only contact was with Ms. Brown and her doctor.
How would you measure the severity of her depressive illness?
At the time that I assessed Ms. Brown, and on the basis of diagnostic interview impressions and psychological tests, I would have characterized her symptoms as severe.
Now, could you briefly describe your course of treatment for Ms. Brown to the court?
Initially, I saw Ms. Brown at least twice a week, and regularly consulted with her family physician and psychiatrist. There was certainly agreement amongst us that she would benefit from medication, and as a psychologist I'm not qualified to prescribe drugs, and so her family physician and psychiatrist have been responsible for managing her medication. Subsequently began seeing her once a week, and over the past 8 or 9 months have seen her bi-weekly in psychotherapy sessions, each lasting approximately 50 minutes.
So do I understand you correctly then to be saying it's a combination of psychotherapy and medication?
I provide the psychotherapy, and the psychiatrist essentially provides the medication component of the treatment plan.
And very specifically, how would you describe or characterize Ms. Brown's mental status or condition at the present time?
At the present time, my observation is that there has been some diminution of depressive symptomatology. I would characterize the symptoms as moderate at the present time, although from time to time probably would have characterized them as mild. The stress of the impending proceedings today have certainly exacerbated her symptoms. I no longer note the degree of thought disturbance that was present at the time that I first interviewed her. and there did not seem to be quite the degree of emotional lability within the interviews that I had observed on first impressions.
Now, I note from your report that Ms. Brown was seen by a Dr. Mary Jones, who's an internist and a specialist in internal medicine, and she has made an independent diagnosis of chronic fatigue syndrome.
That's my understanding, yes.
Now,
I was
what
advised
is-
of that by the family doctor.
What is your opinion on that diagnosis in relation to your own diagnosis of major depressive disorder?
I'm not a medical practitioner. I'm not qualified to evaluate or make a diagnosis of chronic fatigue syndrome, which would be a medical diagnosis. I also do understand that it's a somewhat controversial diagnosis. My knowledge and understanding of the syndrome is that many of the symptoms therein are the very same symptoms that would qualify Ms. Brown for a diagnosis of major depressive disorder, and whether this represents a professional bias by virtue of my training or other considerations, my view is that the depressive disorder is primary in Ms. Brown's particular situation, and may account for at least some of the symptomatology being diagnosed as chronic fatigue syndrome.
I'd like to move now to your opinion with respect to Ms. Brown's prognosis and any recommendations you have for ongoing therapy. What is your opinion regarding her future mental health status, and in particular her general day-to-day functioning?
Certainly Ms. Brown has some obvious strengths as an individual, and pre-morbidly, or prior to the onset of her first major depressive episode, she apparently was functioning quite well within the home as a parent, and previously had functioned well in her job, as I understand it. Ultimately, one would have an optimistic prognosis on the basis of her past functioning. That being said, my prognosis is somewhat guarded in that she appears to have had great difficulty in resolving the issues emanating from the breakdown of her marriage and family, which clearly were the precipitating etiological factors in her major depressive illness. Treatment has been very slow. Predominantly because the early portions of treatment were spent with an almost crisis orientation, providing supportive psychotherapy in large part. The ultimate goal has always been to assist Ms. Brown in accepting her illness, in helping her to develop new and more effective coping abilities that would mitigate against the probability of future depressive episodes. The ongoing unresolved issues related to the marital separation, including those before the court today, I think have created ongoing stress that have made it difficult for us to move on to the more reconstructive work. And accordingly, based on the slow progress of the last 2+ years, it would be my estimate that it's going to take her a considerable length of time to regain her pre-morbid level of functioning. And I have given a very conservative estimate of approximately 4 additional years of treatment before she may be fully functional.
How would you describe her motivation level to participating in the amelioration of her own health problems?
Ms. Brown has been highly motivated. She has, despite the difficulty she has getting out of bed, made it to almost all of our scheduled sessions. When she does come, she's on time. She's verbal, she's responsive to direction. She certainly seems inclined toward self-growth, but regrettably, in terms of retarding her progress, is often preoccupied with current concerns and crises that she perceives.
And what specifically are you recommending for her future treatment?
I think she absolutely needs to continue on medication. Certainly the research is such that recurrences of major depressive episodes are decreased in probability when medication is sustained over a period of several years. I certainly see her continuing in regular psychotherapy sessions, but would hope that over time the frequency of same could be diminished. I don't anticipate, because of the risk of recurrence, terminating her on a permanent basis, but would hope that the therapeutic relationship would remain available to her when required. And I would anticipate that her medical physicians would continue to attend to her physical and medical problems as they have assessed them.
Now, you've indicated in your report and again in your evidence that you have consulted and received information from other healthcare providers, and I wanted to ask you a very specific question. Would your opinion regarding her illness or prognosis be any different in the absence of Dr. Jones's diagnosis of chronic fatigue syndrome?
No, it would not.
And I have one last question for you, Dr. Bukowski. My friend elicited upon the evidence during his cross-examination of Ms. Brown the fact that you had provided her with your home telephone number. Is that in fact true?
No, it is not. I have never in my career ever provided my home telephone number to anyone with whom I have a professional involvement. I would consider that a violation of boundaries and ethical principles. I can only assume that Ms. Brown's evidence represents some form of a delusion based on her dependency on the therapeutic relationship.
Thank you, Dr. Bukowski.
Dr. Bukowski, it's nice to see you again.
It's always nice to see you, Mr. Epstein.
Mrs. Brown has had delusional episodes during the period of time that you have been treating her.
I certainly suspected the presence of delusions on my initial assessment.
And her depression was severe.
I believe that the symptoms were such that they would be classified as severe.
She was virtually incapacitated when you first saw her.
That was my understanding.
Yes. And thoughts of death and suicide are a feature of a major depressive disorder, according to the DSM-4, correct?
They can be,
Yes.
but they are not necessary to make the diagnosis.
Yes, you just have to pick 5 out of the group of 9, correct, Dr. Bukowski?
I don't think it's a question of picking. 5 have to be present in addition to a predominant symptom of depressed mood
Right.
or loss of interest or pleasure
Right.
for an individual to qualify.
And
for that
after you
diagnosis.
had met with Mrs. Brown a few times, you went to look up in your DSM-4 what illness she had, right?
I think that's something of an oversimplification.
Well, you wanted to see if she met the criteria of major depressive
I
disorder.
reviewed the criteria in light of the data, which I've given evidence regarding earlier.
Did she have thoughts of death and suicide?
No, she did not.
So,
Not that she reported to me.
so it's possible that she had them, but she didn't want to share them with you.
That's possible, yes.
But whatever thoughts she had, she certainly at the time you saw her after she was in crisis appeared to be seriously debilitated.
Yes.
Did you pick up the phone and call Children's Aid?
No, I did not.
Were you concerned about her ability to care for the children?
Yes, I was.
And you did not pick up the phone and call Children's Aid.
No, I did not.
Dr. Bukowski, you're well known as a leading child and custody assessor. That's the bulk of your practice,
Yes, it is.
and certainly you've always wanted to be a psychologist. It's not that you tried out psychiatry and couldn't make it, right?
That's correct.
Right. And so you've got no formal psychiatric training.
No, I do not.
But nevertheless, I've noticed in your office when I sit in those interminable visits that you have the American Journal of Psychiatry in your office.
Yes, that's correct.
And you read that to keep up to date.
I read that amongst other journals in order to maintain my level of knowledge and skill in my profession.
It's an important journal, is it not?
Yes, it would be.
Yes. And that journal focuses from time to time on major depressive disorders, is it not?
Yes, it does.
And it's recognized as a leading journal in its field, correct?
I would assume so. I don't have occasion to have a great deal of contact with the field of psychiatry.
And would you be aware, Dr. Bukowski, that the American Psychiatric Association actually publishes treatment guidelines for people with major depressive disorders?
Yes.
Right. And notwithstanding you're not a psychiatrist, those would be the same guidelines you would follow because you and the psychiatrist are both trying to do the same thing. You're trying to help the patient.
Certainly I would agree with many of those guidelines, not necessarily all of them, because I have a psychological perspective as opposed to a psychiatric medical model perspective.
You actually disagree with some of the guidelines?
I would not agree in whole with all of them.
Well, pick one that you disagree with.
I would have to review those guidelines. It's been some
So
time.
off the top of your
So-
head, you can't remember what the ones are that you disagree with.
No, I can't.
That means you probably can't remember the ones that you agree with as well.
Not literally at the moment, no.
Well, let me see if I can help refresh your memory.
Thank you.
The American Psychiatric Association guidelines first deal with the diagnosis, that is, the first step in treating depression. That would be a logical step, correct?
Yes.
First make a diagnosis. So are you familiar, Dr. Bukowski, with what the American Psychiatric Association says should be the first step in treating depression?
Perhaps you could refresh my memory. It's been some time since I reviewed that
Do
document.
you remember?
No, I do not.
All right. It says it is the first step in treating depression is a thorough diagnostic evaluation. Would you agree with that?
Absolutely.
Absolutely. And can you tell me what the diagnostic evaluation would include then?
As I indicated previously, for myself as a psychologist, it would consist of diagnostic interviewing impressions, information obtained from the family physician, the client's self-report. It would also include the client's responses to specific questions that I would pose to her that relate directly to the criteria for a major depressive episode.
Well, the American Psychiatric Association, Dr. Bukowski, says that the evaluation should be carried out by a psychiatrist. You think they're just biased in favor of psychiatrists over psychologists?
Absolutely. I believe that psychologists are eminently qualified to engage in the controlled act of diagnosis and to conduct appropriate assessment, and the Ontario government appears to agree with me.
Do you think a psychologist is equally qualified with a psychiatrist to evaluate and diagnose a major depressive disorder?
Yes.
The American Psychiatric Association says that one of the things that you have to do in order to make a diagnosis is you have to do a complete physical and neurological examination of the patient. I guess you're not able to do that.
No, but I'm certainly able to refer to a medical physician to carry out that component.
And I noticed when I reviewed the notes that you so kindly held back from me until this morning, that you do not have a written report from Mrs. Brown's treating psychiatrist. Is that correct? You do not have, that's a simple question, doctor. You do not have a written report from Mrs. Brown's treating psychiatrist. Isn't that
No.
correct? Right. And you've never seen, therefore, the written results of his physical and neurological examination?
No, I did not. This was conveyed to me in the course of a telephone conversation, and there certainly are notes of that conversation in the file.
Mrs. Brown does not have a history of previous depressive episodes prior to the breakup of her marriage. Isn't that correct?
To the best of my knowledge, this was the first major depressive episode, although she had reported depressed feelings or dysthymic feelings previously.
Did Mr. Bastido tell you that you can't answer yes or no to any question, Dr. Bukowski? That was rather a simple question. She did not have a history of previous depressive episodes. Isn't that correct?
With all due respect, sir, in saying depressive episodes, you could be referring to a broad spectrum of types of depression, major depression being only one of them.
Dr. Bukowski, does Mrs. Brown have a history of depression prior to her seeing you?
Of formally diagnosed depression, is that what you're asking? The answer to that would be no.
Thank you. Does she have a family history of depression?
My understanding in taking the history is that
a yes or a no. Does she have-
maternal uncle had been hospitalized at one time for depression.
Uncle Jerry.
Uncle Jerry.
That was the only person in her family who had a depressive episode.
That was her report.
Did she tell you that Uncle Jerry was adopted?
No, she did not.
You didn't pick that up in your history.
It's not a question I would normally ask. Was the individual adopted?
Well, isn't it important to know in diagnosing a major depressive episode as to whether there's a family history of depression?
Absolutely, and that's why I ask about it.
And if somebody said somebody in my family had depression, you'd want to know if they were genetically linked, wouldn't you? Otherwise, what's the point of asking the question?
Evidently, I wrongly assumed that my client was capable of making that differentiation.
This was a labile, debilitated
Yes.
client who was delusional, and you thought she was
Absolutely.
capable of making a differentiation?
Absolutely. I accept responsibility for that.
Let's see if you can accept responsibility for something else, Dr. Bukowski. This patient has been seeing you for 2.5 years,
That's correct.
and she's not much better today than she was when she started. Is that fair?
My evidence earlier was that there had been some improvement, but she continues to be largely dysfunctional and impaired.
So in fairness, in 2.5 years, she hasn't made much progress.
I'm not sure if I would agree with that characterization. The treatment of major depression is typically slow. She has not responded as well as we would have liked to the medication or to the psychotherapy.
Well, in his 2.5
As I
years,
suggested to you earlier, or to the court earlier, much of the focus in treatment has been crisis-oriented and
Remember
on the
what the question
resolution
was?
of these issues.
do you remember what the question was?
Yes, you asked me whether I agreed that she had made little progress.
No,
in
I actually
psychotherapy.
said, has she made much progress? Can we agree, Dr. Bukowski, that for whatever the reason, which is not the question I asked, but for whatever the reason, she has not made much progress?
Yes,
And she has the same set of 4 or 5 doctors now that she had when we started 2.5 years ago.
that's my understanding.
And
With the
according-
addition of Dr. Jones,
And she's on the same medication for the past 2.5 years.
my understanding is that the psychiatrist has adjusted dosage and tried several combinations of medications along the way.
Well, that's contrary to the notes where Dr. Brown says he's continuing the same medication and dosage. Did you forget that? That's what it says in the notes, Dr. Bukowski.
That is not my recollection.
It's not your recollection. Well, we'll let the judge sort that one out later. So she's with the same doctors, the same medication. Has anyone had the courage to suggest her she try another kind of treatment or another kind of doctor?
Certainly, it is part of an obligation on the part of a psychologist pursuant to the standards of the profession, where treatment does not appear to be largely effective, to suggest alternate forms of treatment and other therapists. And I have had that discussion on occasion with Ms. Brown.
Have you suggested that she try light therapy?
No, I have not.
Have you suggested that she try ECT?
No, I have not.
Have you suggested that she try behavioral therapy?
There are behavioral components to the psychotherapy that I have offered, but I have not suggested a strict regimen of behavior therapy.
Have you suggested she try another therapist?
As I indicated a moment ago, I have certainly discussed
Have you
with her
suggested she try another therapist?
the
It's a simple
possibility
question.
of engaging another therapist, yes.
And she's very bonded and tied to you. She reposes
use the
great
word
confidence.
dependent.
Can you wait till I finish the question, please?
I apologize.
She's very bonded and tied to you and reposes a great deal of trust and confidence in you.
I would not agree with the characterization of bonded and tied.
Well, she
Has
thinks she's
trust-
phoning you at home.
As I suggested earlier, that may represent a delusion based on the dependency in
Well,
the
then she's
relationship.
delusionally bonded to
Your
you.
Honor, I've been very patient with my friend here.
You're never patient, Miss Tellier.
While he's asked the witness to wait till he's finished, perhaps he can govern himself by that same request and let Dr. Bukowski finish his answer.
Fair enough.
Moves on to the next question. Thank you.
Fair enough. But on that point, Your Honor, it would be helpful if Dr. Bukowski did not engage in a speech every time he's asked the question. But leaving that aside. The treatment for depression, according to the American Psychiatric Association, consists of 3 distinct phases, Dr. Bukowski. You agree with that?
Yes.
What are the 3 distinct phases?
Well,
What's
for
the
myself,
first one?
The initial one would be diagnosis. And
No, that's
making
not the first
effective
one. Let's see if you can get the
diagnosis
second one right.
And engaging the client in a therapeutic relationship and developing trust.
No, the American Psychiatric Association describes 3 phases. They have names. What is the name of the first one?
The names and the phases that the American Psychiatric Association refers
Yes.
to. I can't recall.
That's called the acute treatment phase. That's phase number 1. That's to relieve the immediate symptoms of depression. What's the second phase, Dr. Bukowski?
Please go ahead. As I indicated earlier,
don't know?
it's been some time since I reviewed this
Yes.
document.
And what's the third phase?
Termination
Termination of the patient?
is always the final phase of therapy.
I don't think the American Psychiatric
Terminating the
Association is in
treatment.
favor of terminating the patient, Dr. Bukowski, but I guess that's an alternate way of concluding treatment. Dr. Bukowski, your report led me to the Oxford Dictionary last night and a rather fierce debate within my family as to the meaning of biweekly. And not to much surprise, biweekly is defined as once every 2 weeks or twice a week, depending on the context.
Yes.
So, since you didn't say in your report what context you meant, do you propose that Mrs. Brown see you twice a week or once every 2 weeks for the next 4 years?
I believe in my evidence and examination in chief, I indicated that I was seeing her at present every other week, and that it would be my hope to further taper the frequency of sessions as time goes on.
So, Dr. Bukowski, that was really interesting, but it wasn't remotely an answer to my question. Are you proposing to see her twice a week or once every 2 weeks? Which?
Once every 2 weeks.
For the next 4 years?
Some period of time, with the two of us deciding at some point to taper that, probably to monthly sessions.
How much does a visit cost?
$195 per hour.
Right, so that would be $5,200 a year, roughly,
Approximately.
times 4 years would be $20,000.
I don't have a calculator with me, but I'll trust your mathematical mind.
4 times 5 is 20. You can
Yes.
at least agree on that. So, tell me, you think it's going to be 4 years. You think 3 years and 10 months might do it?
It might.
How about 3 years and 6 months?
That's possible.
How about 3 years and 3 months?
It is possible.
How about 2 years and 4 months?
It is possible.
How about 1 year and 8 months?
It's not a question I can make an accurate prediction on because much will depend on the recovery and the removal of major stressors in her life, which include the proceedings before the court today.
Tell me, Dr. Bukowski, a very dangerous question for a lawyer that doesn't know the answer to it, but tell me, have you really treated some patients in psychotherapy for 6.5 years? And they kept coming?
Yes, sir.
Really? Do you think that, in fairness, Dr. Bukowski, your estimate of 4 years is at best a guess?
It's certainly an educated guess, but a guess nonetheless.
Do you think, Dr. Bukowski, if Mrs. Brown is told that she has to come and see you for the next 4.5 years, that might be depressing for her as well?
It might be.
It would be for me, Dr. Bukowski. Thank you.
I have no re-exam.
Thank you.
Guess we're moving to closing arguments. Mr. Grant.
He's not leaving. Actually, could we thank Dr. Butkowski for his presence here? Now, not everybody gets the privilege of suffering at Mr. Epstein's hands. Your Honor, you've heard the evidence over the last couple of days, and I won't repeat it as it would be entirely redundant and unnecessary. But what you have heard and what you have seen is Mrs. Brown, who clearly does suffer from a major depressive disorder, and despite Mr. Niman's attempt to undermine that and, frankly, I'm sorry to say, mock her condition, it is clear that this is a debilitating, long-term illness from which she will continue to suffer for an indefinite period of time. We're not here, Your Honor, as to be crystal ball gazers. I know that's not the function of the court, and it's certainly not the function of counsel. And therefore, as my friend fairly conceded in her opening, we are here to try to ascertain the long-term consequences, if you will, of my client's condition, insofar as that fits on to the legal matrix of spousal support. And as you know, the Divorce Act provides criteria against which the factual evidence is to be measured. And in this case, we are dealing with the economic consequences of two things. We're dealing with the economic disadvantages of the marriage, and we're dealing with the economic disadvantages arising from the marriage breakdown. It's not just one. It could be one. It could be both. It could be either. So what do we know about the Brown family, Your Honor? We know that there was a decision taken that Mrs. Brown would remain at home after the birth of their first child, Marie. We know that up to that point she had gainful employment in the charitable field, and she earned a modest income from that. We also know that from that point in time she did some volunteer work for presumably some degree of fulfillment and some degree of community service. And I would say that even my friend would concede that those were appropriate things for Mrs. Brown to do. We also know that she has suffered very badly at the time of separation, to the point of sustaining a major traumatic episode in her life. And this causal effect, in my submission, deals with the other part of the objective under the Divorce Act, namely the need to compensate Mrs. Brown for the economic disadvantages arising from the marriage breakdown. The disadvantages in this case stem from both the decision during the marriage that she not work outside of the home for money, for remuneration during the marriage, and at the same time the disability that has arisen from marriage breakdown at the end of the marriage, when she is incapable of obtaining or re-entering the workforce, incapable of obtaining full-time gainful employment at this time. And what we know from Dr. Butkowski, Your Honor, is this. We know that it is uncertain as to when, if ever, Mrs. Brown may be able to re-enter the workforce. That's what we know. And I think Dr. Butkowski's evidence fairly put is that it's a guess, but an educated guess as to when Mrs. Brown might be able to find her way through this condition that she has, this serious debilitating condition that she has, to a point where she could begin to consider some options for herself in terms of possibly gaining some enough self-confidence to pursue some type of job or career. What I say about that, Your Honor, in respect of the constructs of the Divorce Act is this, that given that there's an undoubted economic disadvantage that has arisen from the marriage and from its breakdown both, that the only course of action for Your Honor to follow in respect of spousal support is to award indefinite support. There is simply no point and no reason and no justification for awarding any time-limited support. It's simply, on the facts of this case, frankly, Your Honor, makes no sense, and as a matter of law would be doing the very thing that the courts try not to do, which is crystal ball gaze. So there's every reason in my submission, Your Honor, to award simply indefinite support. There's every opportunity for either spouse to seek to vary that if there are occasions of material change in circumstances. And if the Marinangeli case is rightly decided by the Court of Appeal, which we have to assume, then it's incumbent on Mrs. Brown at some point to advise Mr. Brown when and if she may, in fact, be able to re-enter the workforce. Hard to say. But again, as a matter of law, and on this point, I would urge Your Honor to clearly recognize that there is financial need, recognize that it emanates from the marriage, recognize that it emanates from the respective roles that the parties assumed during the marriage, and recognize that as a result of that, there is clearly a need for compensatory, long-term, indefinite spousal support. The only other point I make before turning this over to my friend is this, that insofar as the pension is concerned, you have heard the evidence, and all I ask you to consider, Your Honor, is this, that my client's clear recollection of very telling events, such as the Freedom 55 comment that Mr. Brown made, taken together with the diary entry that she found, provides you with a clear opportunity to say that on the balance of probabilities, it is more likely than not that Mr. Brown intended fully to retire at age 55 to the extent that he was able to do that. And as you know, Your Honor, the civil standard is to make a finding on the balance of probabilities, and Mr. Brown's lame attempt to produce a diary page late in the day that clearly my client hadn't seen in the first place is unlikely, I'm certain, to sway Your Honor from the course that we find ourselves in, where it is almost indisputable that Mr. Brown's intentions were always to retire at age 55. So in summary, Your Honor, on the 2 points in issue, I say that despite the vigorous and at times bordering on abusive cross-examination by my friends, especially of Dr. Butkowski, who I think gave his evidence very, very fairly, and my client, who gave her evidence as best as she could in a very convincing and quiet way, as you saw, that Your Honor ought to award spousal support, and Your Honor ought to find that the age of retirement expected by Mr. Brown was 55, the earliest possible time that he could do so. Thank you, Your Honor.
Thank you. Ms. Hannaford.
Thank you, Your Honor. Oops.
Thank you, Your Honor. There are 2 issues upon which I propose to address the court in this closing. I will begin with the last issue that Mr. Grant addressed, and that is the question that I indicated to Your Honor would be the question for the court. What is the age at which Paul Brown will reasonably retire? Is it 55 or is it 65? And the differences in the evidence may be summarized as follows. Susan Brown says that she recalls conversations about the term Freedom 55 and that Paul Brown said that he was going to retire at 55, whereas Paul Brown has said that he will now retire at age 65. And how does this court resolve those differences? And in my submission, the court should look to the following things. First of all, the court ought to take notice of the fact that what one remembers is often, and it's a human characteristic, is often filtered through the prism of one's self-interest. And I say that, of course, Susan Brown remembers that which, in my submission, advantages her position. But another way of resolving the issue is through the actual physical evidence that is before the court. Of course, Susan Brown focused on one page in the diary, one diary entry. And of course, you will remember what that diary entry contains because Mr. Bastido focused on it and had it read out for the court, that Mr. Brown indicated he wanted to retire, that he couldn't wait till he retired, and he wanted to run a bed and breakfast. Focusing on that one page alone in my submission, there is a great difference between what one wants to do, what one can't wait to do, and what one realistically is going to have to do. So looking at that page on its own, in our submission, that is not dispositive of the age at which Mr. Brown would retire. But if we need one thing to assist in resolving this difference in the evidence, may I suggest that it's in the exhibit offered by Mr. Niman in his very able cross-examination of Ms. Brown, and that is the diary page. And again, I refer to a basic truism, which is that when one looks at documentary evidence, one must examine that documentary evidence as a whole. Mr. Niman provided us with that which closes the circle on the diary, and that is the page that sets out what the true reality is, namely that Mr. Brown is going to have no choice and has always been of the view that he will work until age 65. In conclusion on that first question, it is our submission that the court must answer the question, what is the age at which Paul Brown will reasonably retire? That in that, the court must conclude that Paul Brown will retire at age 65. As a consequence, the value of the pension is as set out before you in the factual agreement, statement of agreed facts. I turn now to the second question, which has occupied somewhat more time of the court, and that is, as I indicated in my opening, what is the support structure that will best achieve the objectives contained in the Divorce Act? Put another way, what is the support structure for Susan Brown that best promotes her self-sufficiency? And the problem for the court are obviously the two positions, namely, Susan Brown in her own evidence says, I cannot work. I will not return to the workforce. My health prevents me from returning to the workforce. I am tired. I am really tired, as she admitted to Mr. Niman. I have lost interest in life. I have been unable to function. I will not be able to function. That, in a nutshell, is what Susan Brown is offering to the court as the reason for her inability to work, and therefore it is the foundation of her request for long-term, non-time-limited support. Set against that, of course, is Paul Brown's evidence, his submission, his position that she ought to, she should, she could, she must work. And it is the position of Mr. Brown that indeed that obligation must be fulfilled for a number of reasons. Number one, Ms. Brown can indeed work. Ms. Brown ought to work because it would be good for her, and Ms. Brown should be found to, in regard to what she tells the court, again, be filtering her views, her self-assessment through the prism of her own self-interest. Another problem in the evidence relates to the evidence of the psychologist, Dr. Butkowski, who says she has at least 4 years to full functionality, that her physical problems continue, and that he is really unable to say when, if ever, Susan Brown will be able to go back to work. In the submission of Paul Brown, that evidence, both the expert evidence and the evidence of Susan Brown, must be tempered against the following facts and the following admissions. And when one examines both what was offered by Dr. Butkowski as expert opinion and what was offered to this court by Susan Brown, when one examines that against these facts and admissions, that it must resolve the problem before the court in favor of a time-limited award. Here are the things that are facts and admissions. Susan Brown has been agreed that, has agreed to, and indeed Paul Brown has agreed that, Susan Brown will be the primary caretaker of the children. Why is that an important fact? Why is that the first fact that I raised to resolve the evidence? 2 reasons. It takes energy, it takes devotion, it takes commitment, and it takes clarity to be the primary caretaker. And indeed, although Mr. Grant referred to the partial minutes of settlement that were to be handed up, I realize that there's been an administrative oversight, and I will offer up to the court now the partial minutes of settlement related to parenting.
Thank you.
And I would turn to just one paragraph that I will outline for the court. And it's the first page of the minutes of settlement, in which it says, and I quote, "The parties agree that each is a loving, devoted, and committed parent, and each undertakes to devote their energies, commitment, and love to the upbringing of the children. Each acknowledges that the other is and has been fully and appropriately engaged in parenting, and both agree that Susan has the time, the resources, and the skills to be the primary caretaker of the children." Your Honor, Susan Brown and Paul Brown signed those minutes of settlement with the advice and the assistance of counsel. Those minutes of settlement contain an undertaking and an acknowledgement. And that is an important fact and an admission to weigh against what was offered by Dr. Butkowski. Secondly, it's important to note that Dr. Butkowski's his evidence, his opinion, was just that, opinion, fairly given. Mr. Epstein obtained the admissions of Dr. Butkowski that he was making guesses, educated guesses, and Dr. Butkowski, if I may submit, made that admission appropriately. He's an expert, and experts don't know everything. When this court examines the expert evidence, again, it ought to put that expert opinion evidence against the stated facts. What are the other facts that helped to resolve the expert opinion evidence. Again, related to Susan Brown, she has no family history of depression, save and except for the adopted uncle, Jerry. That is an important matter to consider in relation to the prospect of long-term chronic continual disorder. Third, the fact is that Susan Brown has made progress. Mr. Epstein obtained that admission from Dr. Butkowski in an interesting way. Dr. Butkowski could not agree that she had made no progress. And indeed, it's important to note that Dr. Butkowski indicated in his evidence that she is, and I quote, and this is from his examination in chief, highly motivated. 2, that she came to sessions on time. 3, that she was responsive. 4, that she was inclined to self-growth. And 5, that she was preoccupied with current crises. What Your Honor should take from that is that when the current crisis, this current crisis, and of course a trial is a current crisis, is resolved, that preoccupation will also resolve. Finally, the court should weigh the opinion evidence and indeed the evidence of Susan Brown against the background facts. The background facts that are not in dispute that I related to, Your Honor, prior to or in my opening statement. Number 1, Susan Brown, by all accounts, and it is admitted, was an energetic, devoted, and committed executive director of the charitable organization that she headed for all of those years before 1992. She enjoyed her job, she was good at her job, and indeed, right up until the time of separation, continued to participate in that sector. All of those facts and admissions taken together, it is submitted, ought to temper the evidence of Susan Brown and the evidence of Dr. Butkowski. They ought to help this court in coming to the conclusion that there is every reason for incentivizing and providing for a support regime that moves Susan Brown towards self-sufficiency, that allows Susan Brown to move forward. Of course, this court should not crystal ball gaze. Of course, this court should not seek to compensate or punish actions through spousal support. Support is compensatory, support is rehabilitative, but primarily support is designed to promote, to the extent reasonable, self-sufficiency. It is the submission of Paul Brown that in order to achieve this goal, this court ought to award a term of spousal support in the amount of $400 per month, deductible, of course, or in such other amount as is appropriate, for a period of 2 years, that the support should be designed to assist Ms. Brown to re-entering the workforce and achieving self-sufficiency, and that a review should follow in order to determine if those goals have been met. Those are the submissions of the respondent. Thank you for your attention, Your Honor. Thank you.
Okay, I guess it's our turn now to provide a judicial commentary. I'm Madam Justice Himmel, and this is Justice Backhouse, and we are justices here in Toronto. And we've been asked to provide a judicial commentary on the various demonstrations you've seen so far. I'm going to comment first about the opening statements, and then Justice Backhouse will deal with the various examinations, and then I'll provide some comments on the closing argument that you've just heard. In terms of opening statements, I think you have to first think about what is the purpose of an opening statement. And an opening statement is really the first opportunity to tell the judge, and if it's a jury case, to tell the jury what the case is about. And it's something that should be carefully planned out and thought about and organized in advance, because it is your first opportunity, and often counsel don't take full advantage of it. But it is an opportunity to set the tone, to give the first impressions to the court on the nature of the case and the strength of the case. And especially important in a jury trial to let the jury know and foreshadow what's coming. The format of it is very important, as well as the manner in which it's given. So it should be given forcefully, and it should really start with a review of the facts of the case. And so when Mr. Grant was beginning his outline, he started by reviewing the facts of the case. He outlined who the parties are. He said what the issues are, and he said what the issues aren't. That's really important too, to say the issues are not custody and access, that's been resolved. The issues are not child support, that's been resolved. Take that all off the table and just focus on what are the real issues. And in this case, the two issues, the issue of the spousal support and the issue of the pension. And that really helps the court focus on what's coming, and when hearing the evidence, really have an opportunity to focus on the evidence from that perspective. And then Mr. Grant turned to what the case is going to be and set out the issues in dispute, as I said, in a manner which I found to be very helpful. It helped me then watch the rest of the case unfold. Ms. Hannaford also did that. She restated the issues, and she said for her the issues are what the structure of spousal support will be that will achieve the objectives under the Divorce Act. So she related it back to the statute. That's important, that we have to bear in mind what the test is. And she talked about the pension issue, and then she related it to what the consequences of the decision will be. That's also very important, to tell the court, well, the consequences will be a differential of $150,000. It will result in an equalization payment with a difference of $77,500. And then she said the evidence will then focus on these two questions. The economic disadvantages suffered and how to promote self-sufficiency. And then Ms. Hannaford gave her version of the facts, and she set out facts that were not an issue. I found that very persuasive in terms of allowing me to understand what's coming, what is not going to be contested, and I noted all of those facts that were not an issue and found, again, those to be very helpful in terms of watching how the rest of the case unfolded. I thought both the counsel were very clear and kept the structure simple. They were forceful and positive without being argumentative. The argumentative style, I think, can come at the end of the case when you're dealing with closings, and I'll talk about that when we get to closings. But I thought both of them were able to outline the facts in a positive fashion and give some foreshadowing of what was coming. It's also important to not overstate your case, because if you can't deliver in the course of the trial on what you say you're going to call evidence on, then you can be sure your opponent's going to remind the court about that. So you want to be very clear about the evidence you can deliver on. And again, I found both counsel were very good at personalizing the client and making the client a real person, and allowing the court to sort of identify the people that were going to be affected by the decision, referring to exhibits that are going to be tendered and the use of the joint exhibit book. and leaving the court at the outset with the theory of the case in a logical way, pointing out an overview of the evidence, and leaving the court with some sense of what was going to be raised at trial. I always also like at the beginning of the case to know about the authorities that are going to be relied upon at the end of the case. I find that really helpful if I have those right at the outset, and then I can review them as the case is unfolding. So those are my comments about both openings, and I guess now turn to Justice Backhouse.
I'm going to provide comments on the direct and cross-examinations. I'd reiterate what Justice Himmel said about focusing on what is an issue and not spending any time on what's not an issue. And that seems like an obvious thing, but it's surprising how much time seems to be spent at trial on things that aren't an issue. So as you're preparing direct examinations and cross-examinations, it wasn't apparent from the examinations and cross that we saw today because it was focused on two issues. But always ask yourself to what issue you're addressing, and because nothing is more boring to the trier of fact than hearing evidence that really isn't in dispute between the parties. So you need context, but not to spend a great deal of time on stuff that nobody is disputing. The other thing that we didn't see in the examinations today was very lengthy cross-examinations, and that seems to be the rule. I think it is rare in a principal witness where a cross-examination is completed in an hour, and those are always the best ones in my experience. So it would be, I think, and it ought to be the exception that if it, for a principal witness to be cross-examined longer than that, and it seems to be the rule that they go on at great length and to not much purpose. By the time Mr. Bastido had finished his examination in chief, I felt very sympathetic to this wife. He started off with leading questions through just the most basic information, and then he set up the sort of abrupt circumstances where she learned that her marriage was over, and then he had her talk about how she left the workforce and the agreement between the husband and wife that she would remain at home to look after the children, sort of setting up her complete dependency on him. I thought it was a very effective development of the negative effect on this particular person of the shock of her marriage ending and her devastation, the fact that her whole world was this marriage, and he brought out a number of sympathetic circumstances. It wasn't just sort of a generalization of a marriage coming to an end in an unpleasant way, but it was very specific about how she was affected by it. In terms of the retirement of the husband, I'm sure if Tom had known that this existed, he would have brought it out in chief, because you've got to get any problems like that solved in chief. She was a sitting duck. And, you know, if he had known, then she would have been able to say there was this other entry in the diary, but it was inconsistent with everything he'd been saying throughout the marriage. And I really think the diary entry that is the relevant one is the other one. Moving on to Mr. Niman's cross-examination, I thought it was really effective. He started off asking her whether she was angry, which suggests to the judge maybe she's being vindictive here, as opposed to genuinely wounded and genuinely depressed. He raises the issue of if she's in such bad shape, how can she look after the children? In fact, she's managing to do that, albeit with help. Then he jumps off the issue of her dependency to the issue of the pension and raises that she has a motive for the evidence that she's a financial motive, namely she's going to gain $78,000 by testifying that he's always said he would retire at age 55. He raised the impropriety of her looking at the diary. He asked if he could approach the witness. And I discussed this with Justice Himmel over the break. I don't actually think in Canada we have any, it's not necessary to ask the judge to do that. However, Justice Himmel raised the point that she always thought it was polite when counsel did that, in the sense that they weren't sort of looming in on the witness. And so I think it creates a good impression. He was able to suggest in his questions that she was a hypochondriac by asking about how many doctors she was seeing, how much time was she spending seeing doctors, suggesting that she was overly involved in this. He then jumped back to the pension issue and I thought raised very effectively the financial changes that have that may prevent the husband from following through on his previous wish to retire at age 55. So it seemed to suggest that you could both find that the wife was telling the truth on that issue, but find that circumstances had changed. They had 2 children who were likely going to need to be supported for many years in post-secondary education. And after all, we had a wife who wasn't taking any responsibility for that. She was taking the position that that was the husband's complete responsibility. So I thought that that persuaded me that things had changed and the financial realities would require him to continue to work, even though he may have previously wished to retire at age 55. He tried to, I thought, effectively get the wife to agree to the positive acts that the husband had done. So she wasn't willing to agree that he had been empathetic to her, but when she was specifically cross-examined on the fact that he hadn't tried to sell the house, that he'd financially supported her without a court order, and so on, I thought that that presented the husband in a very, in about as positive a light as you could, given the negative circumstances. Moving on to Ms. Tellier's examination of Dr. Bukowski. I think she was right from my perspective as a judge to insist on going through Dr. Bukowski's qualifications that were specific to his opinion regarding the wife's illness, and I thought she did that very effectively. I thought she was very effective in getting Dr. Bukowski to adopt the authority on mood disorders and putting that into evidence, which helps bolster his own opinion that it's not just something he's come to on his own, but that he's following scholarly authority on the subject. I thought she was effective in the question she put to Dr. Bukowski with respect to eliciting observations from him as opposed to just what the wife said to him, because some of the time when you're dealing with a psychologist or psychiatrist, it doesn't seem to really be independent of the party's own complaints, but he talked about objective observations that he had made of sadness, tearfulness, and those things were elicited by the way Ms. Tellier put the questions to him. I'm presuming, or else Dr. Bukowski would be able to do this as an experienced witness, but he remained within his own area of expertise and didn't fall into the trap of opining about chronic fatigue syndrome, and she was able, by the question she put to him, able to elicit that his opinion of the wife's illness stood on its own, regardless of the chronic fatigue diagnosis. The cross-examination of Dr. Bukowski by Mr. Epstein was very amusing. I mean, I don't know that anyone else could do it quite like Mr. Epstein does. He starts off by saying, "Nice to see you again," suggesting to me that Dr. Bukowski is such a rounder in the courts that he's constantly being a professional witness. He was able to subtly undermine Dr. Bukowski's qualifications. He didn't object to Dr. Bukowski being qualified as an expert, but he saved that for the cross-examination and is cross-examining him on an area in which Dr. Bukowski is not an expert, but manages to undermine or suggest that his opinion is sort of second best to that of a psychiatrist, I felt. I thought he was able to put Dr. Bukowski on the defensive. He was able to suggest that by not having got a written report from the psychiatrist that he lacked thoroughness. He raised the issue that the wife didn't come with an impediment of a family history of depression. He suggested, I thought effectively, to Dr. Bukowski that Dr. Bukowski had a financial motive for his diagnosis in that he was going to have 4 years of treatment at an hourly rate. And he closed off on a high note by leaving the impression that the opinion that this woman wasn't going to be better for at least another 4 years was just a guess. So that completes my comments.
Okay, I guess I'll turn now to the closing argument. In terms of the closing argument, I often will try to give counsel some time after the case is over to prepare the closing argument. Obviously, this all depends on the length of the trial, but if it's a longer case, in fairness to counsel, you would want to have the time to put together the evidence and the legal argument so that it can be presented in a coherent fashion. So hopefully there's an afternoon that we can stop in the morning and have the afternoon off, or have a day or something between the end of the evidence and the beginning of the closing argument. Because the closing argument is counsel's last opportunity to communicate with the court. And again, leaving a lasting impression, just as the opening was the time to give that first impression, the closing's the time to leave that final impression about the case. And so it's got to be logically and forcefully presented. And to do that, you really have to organize it and plan it in advance. You have to almost have it done before you start the trial, in terms of your outline of where you're going with your case and what you want to accomplish, and then come back to that as you've reviewed the evidence as it is unfolded at trial. And often the best closing really is the one that parallels the opening remarks. It goes back to what you said you were going to achieve in your presentation of the case and shows how you've achieved it at trial. I thought Ms. Hannaford did a good job of going back in her closing to what she said she was going to accomplish in the trial, and as she laid it out in the opening address. I find it very helpful to have some type of written outline. It doesn't have to be extensive, but some outline of what you intend to cover with your oral remarks. Because that's something I can take with me, and it also assists me in following along with the closing argument. Now, I think a closing argument has to have a good structure, And so what you'd want to see is a logical structure, starting with the theory, going to the facts, referring to the exhibits, talking about themes, using rhetorical questions, and perhaps highlighting the strengths and weaknesses of the case, and then leading the court to the conclusion that you want to have drawn. And so from that point of view, that format, I looked at Mr. Grant's and Mrs. Hannaford's closings, and I found Mr. Grant, he started his closing by saying, I'm going to review the evidence as it relates to the issues, again, setting out what the two issues are in the case. Then he related it to, again, the test under the Divorce Act. Really important to go back to what's the legal test that the court has to consider. And then he reviewed the evidence of the witnesses, the parties, and then the expert evidence, the expert opinion, and again related that back to the test under the Divorce Act. By doing that, that led me to this conclusion that I think he wanted drawn, that that I think is very important to always keep in mind. You want the court to come to the conclusion you are trying to reach, the conclusion of indefinite support, and the conclusion with regard to the pension. And then at the end, he summarized the 2 points in issue, again restating the conclusion that he was asking the court to reach. Similarly, Ms. Hannaford started her closing statement by restating the issues, and she had said, as I said earlier, that she related it back to what she was going to achieve in the opening statement. And I thought she used rhetorical questions very effectively. She said, what is the age at which Paul Brown will retire? How does the court resolve it? And then she took us through how is the court going to resolve this and achieve and arrive at the number that she wants the court to find. She also used the exhibits, the diary entry, referred to the exhibits in her closing, and then looked at the evidence of Dr. Butkowski, and again went back to the admissions, the facts that weren't in issue and the admissions that had been made, and itemized them, and then related them all against the evidence of Dr. Butkowski, again trying to lead the court to the conclusion that she wanted the court to reach with respect to the two issues in question. Again, I found quite effective. I think one final comment I would make about closing statements is that, and again, it's got to be related to the length of the case, but closing statements shouldn't be too long. They should be forceful, they should be organized, but they shouldn't go on and on restating all of the evidence. The judge has been there hearing the evidence, and what you want to really do is highlight the evidence and then relate it to the conclusions that you want the court to reach. So those are my comments on the closing statement.
Your Honor, if I could at this point, Mr. Niman and Mr. Epstein and I have conferred, and I've been elected to ask the court to address the issue of costs. No, only kidding. On behalf of counsel, we have thoroughly enjoyed appearing before you, not the least of which reasons is that we don't have to fear or hope for a result, and we thank you for your patience and your deliberations and your comments on behalf of all of us. And may I also take this opportunity on behalf of all of us who participated as counsel to thank Sheila Holmes and Adriana Doyle, who have done such an exemplary job at organizing this. And Sheila is now going to come up, I believe, and moderate any questions that you may have.
Thank you. What we will do actually is take any questions from anyone on the floor, but Adriana and I will take a microphone to each side to save you coming out of those very tight spaces and squeezing to the microphone. So if anyone has a question, if they could just raise a hand, then we'll, good, okay. Let's start. Let's start at the back. And you can give the question to any or all of them.
The approach that Mr. Epstein used in using the magazine to cross the expert on guidelines from another source, did the court not want to see what Mr. Epstein was looking at? And is it not something that he would have been required maybe in advance of trial to file and therefore alert both sides to?
No, in order to be able to do that, you've got to have the witness accept that the article is authoritative. Once the witness accepts that it's authoritative, it's fair game. If the witness does not recognize the authority, then that's a problem. So in preparing and planning for this cross-examination, I considered the source. It did not appear to me that Dr. Bukowski would ever admit that he was not familiar with the American Journal of Psychiatry, which is the leading psychiatric journal. And but I threw in for good measure that I see the journal in his office when I'm there. Actually, I glaze over when I'm there. I don't see much at all in the office, but there's never usually much good news when you go to that office. So I need him to identify the journal. If he doesn't identify the journal, you can't ask the witness about it. So if it's authoritative and he accepts it, then it's fair game and it's not an exhibit. And with the greatest of respect to the two learned justices, the three counsel here all think that the DSM articles and other stuff is not admissible evidence and can't go in as exhibits. You cannot, I respectfully believe, you cannot put in exhibits from other books. You can put them in for the judge to follow as evidence, but exhibits are evidence, and textbooks are not evidence.
Nicole, do you want to?
That's not what Justice Zabinka says.
Okay.
Why was the decision made not to call the husband as a witness?
Time.
Sorry. Again, please.
There was no time.
Just timing for the demonstration. We just chose two witnesses. I think there was a question here.
Madam Justice, in the closing statement, is it appropriate for counsel, besides reviewing the facts and the evidence, to intersperse the case law referring, this is like what was decided in this case and so on?
Yes. And I agree with Justice Himmel's comment, just as a side to that, about the helpfulness of getting the case briefs at the start of the trial, because sometimes you can't for the life of you figure out why certain evidence is coming in, but when you read the cases that they provided you, it's clear. So it's helpful to just allow you to focus in on what the issues that you're going to have to decide on.
I was wondering if Your Honor could comment on, from a judicial perspective, on the approach of trying to keep the witness on cross-examination to yes and no answers. I know that that's a common approach, but where the witness is not going on unduly, like rambling, and counsel is, in some instances, I would suggest, with respect, cutting the witness off in his answer. And I know Ms. Tellier did object at some point. Is that something that the court kind of frowns on or whatever interject, or do they just leave it to counsel to try and deal with that in reply?
Stephen and you on this issue.
I'll just put in my 2 bits, and anyone else who wants to say anything. I think in the case of Dr. Bukowski, he was not going on, and I don't think he should have been restricted to a yes or a no. But there are many witnesses who do go on, and in that case, it really could be answered by a yes or no, and it should then be.
So this is a very difficult and very serious issue, because if you, when you proceed with this course in the January 29th, and you go into workshops, and when you ever go into advocacy workshops, and you're taught about cross-examination, you're taught primarily to try to design questions that elicit yes or no. And because you use the Socratic method to build up, and you do not run the risk, if you're asking open-ended questions, of the witness telling you something that you don't want to hear about. And therefore, you can get a yes or no, and if you get a no when you anticipated a yes, you can move on. So the question is, what do you do with a witness like Dr. Bukowski, who, from long experience in the witness box, refuses to answer yes or no to the most simplest of questions? Really, to the most simplest of questions, and I have watched him in the witness box over the years. This is only the second time I've cross-examined him, both in mock trials, but I've had him as a witness in chief on occasion, and he will not answer yes or no under cross-examination. He's clearly been well trained in that regard. So that throws off a cross-examiner, particularly a cross-examiner of my particular style. And always you have to develop your own style and be your own person. So I have trouble with someone like Dr. Bukowski, and because it's combined with my attention deficit disorder, I feel impelled to try to cut him off and restrain him. I think it is the role of counsel to control the witness, but as a matter of law, you are not entitled to a yes or no answer. The witness is entitled to explain, save one exception. If the question calls for a yes or no answer, the witness is not entitled to give a speech if it's a simple question. The problem is how to design your cross-examination so that the question is so simple it calls for a yes or no answer. And that's very hard to do. You are clearly not permitted to say, answer the question yes or no, because if you do that, counsel will be on their feet saying the witness is entitled to fully answer, and the judge will say the witness is entitled to fully answer. I get away with interrupting because I've just been doing this way too long, but it's not appropriate, and you shouldn't do it. Some judge, if I interrupted in a real courtroom setting like that, I would get into a lot of trouble. So when you do these kind of exercises, you do get carried away by the spur of the moment, and he is particularly infuriating because he won't answer a question yes or no. But it's not good practice, except where the witness will not, as Justice Backhouse says, answer a simple question. Stevens probably has some thoughts on this too.
I was going to agree with Phil, and the judge will tell you if you are having a problem with the explanation that's coming out of the witness that you can deal with some of these things in re-examination if you have to. So, but the trick is, and when you're cross-examining somebody, is to control that particular witness, and whether if it calls for a yes or no answer, that's what you're trying to elicit. It's as simple as that.
Yeah, if you can't control the witness, you should get rid of the witness and get the witness out of the witness box. In your life experience when you do trials, I will tell you from 35 years of experience, witnesses will hurt you more than they will help you. If I could do a trial with no witnesses, I'd be very happy. If you can't control the witness, don't play with the witness, and particularly someone like Dr. Bukowski, who will really do you a lot of damage. Control is the name of the game. And some witnesses, like Mrs. Brown, said yes or no to Harold. She was a bit traumatized. So after a little while, she began to say yes or no to everything, including some outlandish suggestions. That is, for you, the perfect witness.
Mr. Epstein submitted into evidence a document, or a page rather, from the husband's diary.
Mr. Niman did.
Okay, sorry. And I guess that apparently was not in the affidavit of documents. Why were there no objections to this?
They were too stunned.
You know, my husband refers to that as the chutzpah rule, that you just get it in and things have moved on before anyone realizes.
Yeah, I think that's just the license of this kind of demonstration more than anything else. I think that if it hadn't been produced before trial, then I'm sure you would have had an objection in the real world.
Any other questions? Good.
just had a question for Mr. Niman. Actually, Justice Backhouse had said that part of your style was that you were suggesting, you made suggestions to the witness when you were cross-examining her. I guess one point was when you suggested that she was angry. Another one was that you raised the impropriety of her looking at the diary. But you didn't go further than that. Is there a reason why you didn't go further than that and make a conclusion?
Well, in part, it was the time constraints. I had about 15 or 20 minutes. The other reason is, how far are you going to take some of these issues? The woman was clearly devastated by the breakup of the marriage. I wasn't going to change that. And the best I could do was to try to establish that she was a bit of a hypochondriac and she was motivated more by her anger and bitterness, which I would have probably developed depending upon how the answers that you get. I don't plan my cross-examination that meticulously to the extent that I sort of follow it by rote. I go where the evidence takes me and how the witness seems to be responding, and I have an idea where I want to go at the end of it. And if I think that it's enough at that point, then I make an instinctive judgment call and just leave it. The issue, whether or not she had a right to go into the diary, was entirely irrelevant. It didn't help me one bit. It wasn't. I didn't think that I was entitled to bring a motion to suppress evidence or call for a sidebar with the court, because I think that only happens on American television. So the evidence was going to be admissible in any event, and the most that I could do with it was to establish that she was snooping around and hadn't really been candid with the court about what she found.
I think you have to appreciate that some of cross-examination, like Harold's or mine, might have spent the first half an hour in what one would euphemistically say was softening up the witness. I had much more interesting things to canvass with Dr. Bukowski and Harold with Mrs. Brown, but I first want to get the witness into a pattern. Harold was fortunate to be able to get her into a yes or no pattern quite early. I was still working on it when I decided to quit. For example, there's a whole body of literature about CFS patients and MMD patients should go out in the workforce, and they have a better prognosis when they go out in the workforce. There's a whole bunch of literature things to put to the doctor, but I first want to spend some time with him trying to upset him a bit, and that's why I got a bit into how well he knows his psychiatric jargon and how well he knows the literature. So you can't, while I agree with Justice Backhouse, you're trying to do this in an hour at a trial, you'd really probably spend 2 hours with Dr. Bukowski and maybe 2 hours with Mrs. Brown in order to try to soften up some of these areas. So questions that may look a bit irrelevant, the diary from my perspective I thought was irrelevant too, but on the other hand I thought it was very effective because it intimidated Mrs. Brown, and not every examination has to be about intimidation, but sometimes they are.
I have a quick technical question. I noticed that an order was made excluding witnesses, and Ms. Brown was not present during the opening, and was that intentional? And secondly, I was involved in a trial recently where this occurred. In the event that counsel chooses to call a witness before their client testifies in chief, but remains in the courtroom, the rules of civil procedure seem to provide some assistance in this regard, but the family law rules, I feel, do not. What comments can you make with respect to this tactic and how it may affect the ruling with respect to what weight is given to that particular individual's evidence?
Parties never excluded. When an order is made excluding witnesses, they are the exception to that. And I wouldn't have thought that Dr. Bukowski had to leave for the opening. It would just be one, like they're excluded from the evidence, hearing the evidence. But
no, I'm sorry, I'm referring to the actual client.
The client would never have to leave. But I didn't hear the second part of your question.
Sorry, just with respect to the family law rules don't really focus on this issue. I think there is some clarification provided by the rules of civil procedure, but not by the family law rules.
In terms of parties being in the courtroom?
That's right.
They don't ever have to go.
Can I just comment on that, Justice Backhouse? It is my view sometimes, and I asked my client to leave the courtroom I think sometimes when the evidence basically is a narrative evidence, it gives more weight to the witness if the witness does not hear the opening statement, especially if the opening statement goes to the facts, which the witness is then supposed to say in some detail. And while I recognize that the party does not have to be excluded, it always seems to me to be sort of an odd sort of rule. If you are going to tell a story, then obviously if the person is in the courtroom hearing the story and she's going to give evidence immediately thereafter, it seems to me that the story loses some credibility.
I just have one more question for Mr. Epstein. When you began to question Dr. Butkowski, you were questioning his qualifications, but as I understood that he'd already been accepted as an expert witness. Was that proper to question his qualifications like that?
Well, you have two choices. Ms. Tellier is supposed to go over his qualifications and then tender the witness to see whether I want to challenge his qualifications. If there had been time in this case, I probably would have then voir dired Dr. Butkowski about his qualifications because of the lack of familiarity with mood disorders on his resume. But I chose not to because of the interest of time. But nevertheless, if I decided in a real trial he was going to get in anyway, I'm still entitled to deal with his qualifications as part of his evidence in chief. I make the decision about whether I'm going to knock out an expert as to whether I really think I can knock out the expert. If I think I can knock out the expert, then I'll voir dire and challenge it. If I don't think I can, then I'll take some shots at the expert in the witness stand.
Just a further comment on that. When you're setting up your qualification of your witness, it's important to limit it to obviously what your expert's qualified to do, but to tailor it to the specific area. What both counsel and the bench didn't want to hear the detail, which is quite common. What I would have concluded in saying or asking the court to do was to specifically ask that he be qualified to diagnose and treat, and use those words, mental health disorders. That being said, you can still highlight a particular witness's experience in an area that's important, like mood disorders, but your qualifications can be more general or more specific as it assists your case.
Thank you. We'll take the last question.
Thank you. When do you seek to provide independent proof of hearsay relied on by an expert?
Well, it depends on how much the expert has used it to come to the conclusion, and you would want to elicit that in your examination in chief. So, for example, if your expert was not a treating therapist, as it was in this case, but had been hired solely for the purposes of litigation, he or she would likely have reviewed the clinical notes and records of the treating therapist, and so therefore that person's opinion would contain some hearsay. It is admissible under the principles set out in Lavallee, although it goes to weight. So you would make everybody aware of how that evidence was reviewed and that it's a matter of weight. But it is an exception to the admissibility of hearsay in this context.
I should add that the case law fully supports the position that if Dr. A relies upon an opinion of Dr. B in Dr. A's report, then Dr. B is liable to be subpoenaed and cross-examined on that opinion.
Thank you. I think that's the end of the questions. Thank you very much for your attention. Thank you especially to the people who participated today and worked hard on their preparation. And thank you, Your Honor, for your comments. We have the third part of this program for those of you that are attending in January, which will be skills training, where you get to do all this stuff yourself. Thank you.